The Supreme Court just smacked red flag laws right in the mouth, and that's only the start. There are 9 other rules getting chewed up in the courts right now, and if even half of them stick, the gun world's about to look a whole lot different for folks like us. What's up? This is Scott from Line 45. Today, I'm going to break down these court fights one by one. No lawyer talk, just straight up what it means if you own, carry, or even just care about your guns. Before we dive in, do me a solid. Smash that subscribe, tap the bell, hit all the dang buttons down there. You don't gotta, but it keeps this train rolling and lets me crank out more of this wild gun talk for y'all. Alright, enough of that. Let's get back to it. Digital privacy for gun owners. Here's the deal. Courts are starting to wake up to how much tracking is baked into modern life, and gun owners are right in the crosshairs. The big question is whether the government can use your phone or digital data to figure out when you're carrying or when you walk into what they call sensitive places, like schools, post offices, or government buildings. The Supreme Court has already said in Carpenter v. United States that police need a warrant to pull your cell phone location history, because that's basically a GPS ankle monitor in your pocket. Now, the same logic is sliding over into Second Amendment cases. Think about it. If the state can ping your phone and know exactly when you step inside a courthouse or drive past a gun-free zone, that's straight-up surveillance. That's not the same as an officer eyeballing you. It's constant, automated tracking. Some lower courts, especially in the Ninth Circuit, have hinted that combining digital registries with location data is unconstitutional. That means tying gun ownership to live surveillance could be a Fourth Amendment violation. For us regular folks, this isn't about hiding anything shady. It's about not being treated like you're on parole just because you bought a Glock. Privacy is part of freedom. And if these rulings keep stacking up, the government's going to have a lot less room to snoop on law-abiding gun owners through their phones or digital trails. Vehicle Safe Harbor Doctrine. So here's how this one shakes out. You're driving with a gun in the car. You've got it unloaded, locked up, ammo separate, the whole 9 yards. You're doing it right. But for years, cops in certain states treated that like a free pass to yank you over and dig through your stuff like you were smuggling dope. Total headache. Now, the courts, especially in the Fifth Circuit, are starting to call BS on that. They're saying just having a properly stored firearm in your vehicle doesn't give police automatic probable cause. And that's big, because it gives guys like us some peace of mind when we're traveling. I've been on long road trips with a pistol in the trunk, and the last thing I want to deal with is an officer trying to make it into a bigger deal than it is. Safe harbor means if you're following the law, locked case, unloaded, ammo separate, they can't treat you like a criminal just for hauling your own gear. Makes crossing state lines a whole lot less stressful. Universal carry standards. Now this one really gets my attention. You know how some states drag their feet on permits? Like you apply, you sit around for months, and maybe they kick it back because you didn't show good cause, or whatever nonsense they come up with. Total runaround. Courts are finally starting to put their foot down on that. The way it's shaping up, permits should be handled quick, like 30 days. None of this 6-month waiting game. And those good cause requirements? Gone. The courts are saying the Constitution is your good cause. Fees, too. Some states want a couple of $100 just to process paperwork. Judges are pointing at that and saying, no way, $50 tops, keep it fair for the average Joe. To me, that's common sense. Owning or carrying a gun shouldn't feel like you're buying into some exclusive club. It's a right, not a privilege. If these rulings keep landing the way they have been, we're looking at a future where carry permits are standardized across the board. Reasonable fees, no silly hoops, no waiting a year just to get told no. That levels the playing field for everybody. Ammo protections equal to firearms. Okay, so here's something that doesn't get talked about enough. Everybody always says, yeah, the Second Amendment protects your guns, but what good is a gun without ammo? That's like buying a truck with no gas. Courts, especially in the D.C. Circuit, are starting to look at that exact question. Does the Constitution protect not just the firearm, but the ammo it eats? And honestly, it makes sense. Think about it. States like California and New York have tried to impose limits on ammo sales background checks for a box of 9mm, caps on how much you can buy in a month, even bans on shipping it straight to your door. Total headache. Well, judges are beginning to say, hold up, if the right to keep and bear arms means anything, it sure as hell covers the ammo too. I've seen guys get turned away because they hit their state's purchase limit, couldn't even grab an extra couple of boxes for range day. That's not safety, that's just punishment for regular folks. If these rulings stick, ammo restrictions could get tossed right alongside bad gun laws. And honestly, That levels the field. Criminals don't follow ammo rules anyway, so all those laws ever did was screw with people like you and me. Bottom line, gun rights without ammo rights don't mean squat. Courts are finally starting to connect the dots, and if they keep pushing, it could blow the doors wide open on how we buy and store our rounds. Ghost guns and home manufacturing. This one's been hot for a while. The ATF's been trying to crack down on so-called ghost guns. You know, unfinished lowers, 3D printed parts, stuff you can build out at home without a serial number. They rolled out that whole rule saying even an 80% lower had to be treated like a firearm. Courts, especially in the Fourth Circuit, are starting to smack that down. The logic is simple. Americans have been building guns at home since before there was even an ATF. It's tradition, it's legal, and unless you're selling them, Uncle Sam shouldn't be in your garage. Here's where it gets interesting. Judges are hinting that forcing serialization on a homemade gun might actually violate your rights. Why? Because the Fifth Amendment says you can't be forced to incriminate yourself. Slapping a serial number on something you built could be seen as admitting you did something illegal, even when you didn't. That's a wild angle, but it's catching traction. And let's be real, bad guys aren't waiting in line at Home Depot for an 80% lower kit. They're stealing guns or buying them on the street. These rules only choke out the regular hobbyist, the guy in his garage with a drill press who just loves the freedom of doing it himself. So yeah, if these court rulings keep falling, the ATF's ghost gun rule is on borrowed time. Home builds could stay just that. Your business, your project, no government nose in it. Mental health firewall. So here's one that hits home for a lot of vets, first responders, and honestly just regular folks going through stuff. For years, if you checked into therapy for PTSD, depression, or even addiction, that could come back and bite you when it came to gun rights. Like, you do the right thing by getting help, and next thing you know, the government's treating you like a ticking time bomb. Total backwards logic. Now, the 11th Circuit has been pushing back. They're saying you can't just strip somebody's rights because they sought treatment. The only way you lose your guns is if a court, with real due process, says you're actually dangerous. And that's the way it should be. Otherwise, you're just punishing people for being responsible. I've had buddies who avoided counseling because they were scared they'd get flagged in some system and lose their guns. That's crazy, right? We tell people to get help, then hang their rights over their head. These rulings are basically putting up a firewall. Treatment stays treatment. It's not an automatic scarlet letter on your Second Amendment. Now, if a judge looks at the facts and says, yeah, this guy's a legit danger, that's one thing. But a blanket policy that says therapy equals no guns is lazy and wrong. Courts are starting to get that. And if this keeps rolling, it could mean that more folks finally feel safe enough to get the help they need without worrying Uncle Sam's gonna come knocking. National reciprocity mandate. Now this one would be a game changer. Right now, carry permits are a total mess. Some states honor each other, some don't, and some treat you like a felon the second you cross the border. I mean, you could be legal in Texas, drive into New Jersey, and suddenly you're looking at handcuffs for the same Glock you've carried for years. Makes no sense. Courts in the Third Circuit have started hinting that this patchwork system might not fly anymore. They're looking at the full faith and credit clause, which basically says states have to respect each other's laws and records. If that logic sticks, your carry permit would work nationwide, just like your driver's license. No more guessing which state map has your back. For folks who travel a lot, truckers, sales guys, or just families on vacation, and that's huge. I've had customers tell me they leave their carry piece at home just to avoid the hassle. This could flip that. Now, states like New York or California won't love it, but if the courts force reciprocity, it levels the field. One permit, every state, same rules. That's freedom that actually works across the country. Red flag law shutdown. Red flag laws have always been touchy. The idea is simple. Family, a neighbor, or even a cop says you're dangerous, and a judge signs off on pulling your guns. No charges, no conviction. Sometimes you don't even know until the knock hits your door. Sounds quick, but the problem is, it skips the part of the Constitution that says you get due process before losing your rights. That's where the Supreme Court is leaning. Since the Bruen decision, every gun law has to line up with American history and tradition. And when you look back, there just isn't an example of the government taking weapons from someone based on a tip or a suspicion without proving it in court first. That history test is what's killing a lot of these newer laws, and red flag rules fit right in the danger zone. The Fifth Circuit already set the tone by striking down the gun ban for people under domestic restraining orders. The court said it didn't pass the historical sniff test. Red flag laws look even weaker under that same standard. What this means for regular folks is pretty straightforward. If the court keeps pushing this line, states won't be able to yank guns first and ask questions later. They'll have to charge you, prove you did something criminal, and let you defend yourself before they touch your property. That's the way it should have been all along. Registry database destruction. Have you ever bought a gun and filled out that Form 4473? Yeah, the stack of papers the dealer has to keep on file forever. Well, the ATF's been turning millions of those old records into a giant searchable database. They claim it's not a registry, but come on, if it walks like a duck and quacks like a duck, it ain't a chicken. Right now, there are over 1 billion records sitting in that system. Some courts, especially out of DC, are starting to look sideways at this whole setup. The Firearm Owners Protection Act of 1986 flat out says the feds can't create a national gun registry. Period. By scanning all these records into a central system, ATF is basically skirting the law and hoping nobody calls them on it. Judges are finally saying enough. If the ruling holds, ATF might be forced to dump those databases and destroy what they've already digitized. That would be huge for privacy. Imagine every gun you've ever bought sitting in a searchable file, waiting for some bureaucrat or hack to pull up. That's not about solving crimes. That's about control. Getting rid of it means you're not tracked for simply buying a hunting rifle or a carry pistol. If this sticks, the only records left are the old-school paper copies sitting at your dealer. And unless you commit a crime, nobody has any business digging through those. Qualified immunity reversal. This one right here flips the whole script. For decades, cops and government officials leaned on something called qualified immunity. Basically, if they violated your rights, you couldn't really sue them unless there was already a super specific case saying that exact thing was illegal. So even if they stepped way over the line, say, taking your guns without cause, they'd usually walk away clean. Now, courts in the Eighth Circuit have started poking holes in that armor, especially when it comes to the Second Amendment. The idea is simple. If an officer clearly knows what the Constitution says, and they still trample your gun rights, they can be held personally liable. No more hiding behind the badge. You can drag them into civil court, and that paycheck or pension could be on the line. That's a big deal for accountability. I've heard too many stories of guys getting their firearms seized under bogus charges, or permits yanked just because some sheriff didn't like the idea of concealed carry. Before, your only option was to eat it, or spend years fighting the system. Now, the officer himself might have to answer for it. Look, this doesn't mean every cop's in danger of being sued for doing their job. It means the ones who blatantly ignore the Constitution don't get a free pass anymore. And if that doesn't put some respect back on the Second Amendment, I don't know what will. So when you step back and look at all this, the privacy rulings, the ammo fight, ghost guns, reciprocity, red flags, even cops losing qualified immunity, you can see the courts are finally forcing the government to play by its own rules. For years, agencies like the ATF and certain states stretched the law, hoping nobody would push back. Now judges are saying, nope, the Constitution means what it says. For us, it's simple. If even half of these rulings hold, we're living in a totally different gun world. One where buying ammo isn't treated like a crime, carrying across state lines isn't a gamble, and your rights don't vanish because somebody made a phone call. That's the way it's supposed to be. I'm curious though, out of all these 10, which one do you think changes your day-to-day the most?